the Crimes Legislation Stalking and Harassment Amendment Bill?
That legislative statement is published under the authority of the House and can be found on the Parliament website.
I move, Mr. Speaker, I move that the Crimes Legislation Stalking and Harassment Amendment Bill be now read a third time. Mr. Speaker, stalking and harassment is vicious, sinister and can be deadly. After years of discussion, this government has strengthened the law to put a stop to this insidious behaviour and to keep victims safe. Stalking and harassment, sadly, can affect any New Zealander. However, women are greatly overrepresented as victims by the deluded, the sexist and the abusive. Even worse, their children are frequently exploited to surveil victims, pass on threats or even be threatened themselves. This bill will help to protect everyone, but especially women and their families. This bill would not be possible without the tireless advocacy and help of many people. Last year's petitioners championed this cause, and I want to personally thank the Coalition for the Safety of Women and Children for organising the petition. I'm pleased that as a government and indeed as a parliament we've been able to keep our commitment to pass legislation before the end of this year. I also want to thank the more than 600 submitters to the Justice Committee. Many of them bravely shared their own stories, experiences and the impact of stalking and harassment on their lives. The Justice Committee itself deserves special thanks. They listened carefully to those stories to improve the bill for everybody's benefit. The committee's work that shows that when an important issue comes up, the House can work together to make a difference for all New Zealanders. I'd like to take a moment to step through the important aspects of the bill. The bill amends the Crimes Act to create a new offence of stalking and harassment. The new offence is defined as a pattern of behaviour which the offender knew was likely to cause the victim fear or distress. The pattern of behaviour is defined as 2 specified acts within a 2-year period. These specified acts are listed in the bill and are broad. The police notice system and relevant defences are also built into the new offence. Supporting amendments are made to other legislation. These changes increase protections for victims and their families. Protections include allowing the Harmful Digital Communications Act and restraining orders to be made at a sentencing for the new offence, adding the offence to the firearms prohibition order regime and preventing intimidation when giving evidence. Together, the offence and these supporting amendments provide a comprehensive response to criminal stalking and harassments. This has all been drafted very carefully. Stalking and harassment is difficult to address because it can be done by any person in any way to anyone and can occur through an open-ended list of behaviours, making up a pattern of behaviour. The bill cuts through this problem with a solution, a wide net. It's drafted to be absolutely clear that a wider range of behaviours can be stalking and harassment. What really matters is the impact of that behaviour. And so it casts the net in 3 ways. First, the specified acts are drafted broadly. They capture many different forms of stalking. As an example, many people asked if a specific behaviour of making intimate visual recordings would be captured by the bill. I'm pleased to say absolutely. This behaviour is captured by the widely defined specified act of tracking or recording. This specified act could also capture audio or any other kind of intimate recordings made in public or private. Second, the bill states that a specified act is captured if it is done, quote, in any way, including directly or indirectly. This makes it clear that a stalker or harasser cannot work around the offence with technology or covert strategies. To continue my previous example, people asked if using spyware apps to film victims through their phones would be captured. Again, this is captured by the specified act of recording or tracking with the assistance of these in any way rules. Third, the bill states that a specified act is captured even if it is done through a third party. This might include a friend, teacher, relative or even a business. This addresses an especially worrying problem I mentioned earlier, abusing the trust and innocence of children to stalk parents. This might be asking a child to pass on threats to their parent, spy on their parent or even stalking the child itself. Of course, the other defining feature of stalking and harassment is its repetitiveness. In this bill, a pattern of behaviour. It's been a subject of extensive debate in the media and in this House. As a result, the bill has changed through the select committee process and has a wider pattern of behaviour of 2 specified acts in 2 years. This is an important refinement of the bill. Similarly, the mental element, the mens rea for this offence, which has also been heavily debated and just also in the committee stage. I do remain satisfied that the current standard quote, knowing that the pattern of behaviour is likely to cause fear or distress is appropriate, for two reasons. First, that the standard does capture the many motivations behind stalking and harassment. Those opposed to the standard argue that defendants will get away with stalking through their lies and delusions. And I understand that worry, but I have every confidence that our prosecutors and ultimately our juries are not so easily fooled. In many cases, knowing fear or distress was a likely outcome will be implicit by the nature of the behaviour, for example, where threats of harm are made. But in other situations, a prosecutor might only need to show that if a victim, a friend or a family member told the stalker they were scaring the victim. And then thirdly, there's a police notice system takes it further if it's issued to a stalker but the behaviour continues. A presumption of knowledge is established against the stalker. Second, as lawmakers are responsible for maintaining proportionate offences, the offence has a significant maximum penalty of 5 years imprisonment. And if we lower the standard to such as ought to have known, alongside the very wide net of specified acts, we risk losing proportionality. And so I understand why people feel very strongly about it, but I'm convinced that the current draft and legislation achieves the right and appropriate balance. I'm mindful that laws are only effective as their enforcement, and to give the police agencies time to properly prepare for the new offence, a bill will come into force 6 months after the royal assent. Time will be used to set up the systems necessary for an effective response. Before I conclude, I'd like to thank advocates, submitters and members of the House who have supported this bill. It's been a long time coming, and this has been a very busy government in the justice space. We've passed a lot of legislation, but I'm very pleased that we've been able to find the space and the time to get this legislation through. And I want to thank the House for their support in doing this. This is a victory for the people who have argued for it for so long, for their families and for our broader society, because it sends a very clear message. And it sends a message to people who think that it's appropriate to get away with these sorts of activities, that society does not accept it, will not tolerate it, and will deal quite harshly with people who stalk and harass their fellow New Zealanders. Mr. Speaker, I'm proud to say I commend this bill to the House.
Okay, so overall, very good bill. My only concern, though, is the lack of an objective, reasonable person test. That's what's used in Australia, and it's designed to be objective in the standard of care that of a reasonable person is that the person's position is determined to be on the basis of what the person knew or ought to have known at the time. So the test that should have been included, it operates fundamentally as a legal fiction that enables courts to establish consistent standards of behaviour across society. So, what would a reasonable person do in this situation? So the reasonable person is not the average person, according to the paper that I'm reading, nor is they exceptionally cautious or skilled. Rather, they represent a standard of ordinary care. So, for an example, if a driver runs a red light and causes an accident, the court considers whether a reasonable person would have acted differently, if so the driver may be found liable. However, in an unforeseeable event, such as a sudden brake failure occurs, even a prudent driver may have not avoided the harm. So, yeah, basically including that test probably would have helped a bit because, that's kind of like a loophole that's been left in there. I hope eventually it does get amended in to protect more people. By the way, that objective reasonable person test takes into consideration whether or not a person has an intellectual disability or not, or whether they're blind, or whether it takes into account all the disabilities and everything. So yeah.
It means you won't sit there and basically have someone being purposely set up to fail.
Yeah.
Well, I think I found an idea of an emoji that we could upload for something in a future date.
Oh no, it's AI generated.
Oh, no. It's about the pie time.
Oh, Jerry.
Every time the bell rings, it goes, pie time.
Yeah. I could have Jerry of a pie. Sure, why not?
Yeah. That's something. Yeah, no. We won't use AI generator for the emoji.
No, I want to make those emojis because I do like making emojis.
Oh, yeah. Yeah. Okay, let's get on to Tamma for Paul.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok. Who's got the order, paper pie?